Exciting. Did you have to make some calls?
There were a lot of calls made for a lot of songs in this movie. Honestly, like this movie, I think that like when you see it, it feels like a big, beautiful summer movie, but like we didn't have any budget. So there were a lot of favors and a lot of begging and
Your niece for Taylor?
I mean, honestly, she was with me on this experience the whole time, all throughout it. So like she really lived this with me. Yeah, she was, she's a person who shows up for you, and I'm so grateful to have that love and that support. But yeah, there were other people too that I had to call and beg, and people that said no. But I don't know what that means. So if somebody has a dictionary, I would love to find the definition of that. It's so confusing to me. No, we just begged to get a lot of the songs in the movie, songs that we couldn't afford, but people.
Hi guys, welcome to my channel. What if I told you that in December, Blake sent out a press pack to other media outlets and provided them with an attachment of screenshots that were never ever sent to the CRD? What if I told you that in December, the LA Times printed with an attachment an exhibit that contained pages of text messages that are not included in her complaint? Today, Blake's complaint, and also check as far back as May of 2024. And what if I also told you that none of those text messages ever actually existed in the CRD complaint, nor were they brought before the CRD, and yet several of these text messages also refute many of her claims regarding a smear campaign? The reason Justin Belden and Wayfair are so confident in their case is because they know nothing ever smeared. Why? Yes, I told you that I have talked to an insider, and I've also spoken to people who know Justin, and I've talked to people involved in the movie. And it's a matter of fact that there was no smear campaign, because there was only a relatively short time frame when the smear campaign could ever possibly have occurred, because Blake announced it was a smear campaign day one. She was already pointing the finger at that story of retaliation from day one. Any negative criticism that she got, she was going to blame as part of a smear campaign. That was the motive because of the clause of retaliation, since she had included a 17-point agreement where she would sue Justin Baldoni. Of these exhibits that she submitted, which are not privileged because they're not attached to any document, and they weren't even submitted at all to the Department of Civil Rights for the state of California, I have a full FOIA request, which provided me with all the documents that are available from the CRD, and I can say truthfully that these exhibits never were submitted with the CRD. These were published by the LA Times and were also featured in the New York Times. And right on the first page of this one, a text message which she is actually ignoring and verifies Ryan Reynolds' participation, and it verifies the reason why Mr. Baldoni, Justin, began taping everything that was happening. I mean, they had done it before but got more into documentation of all the communications because of what was happening and the threats they were receiving when they were in war over the cut of the film, and Blake was haggling about editing, and they were having these screenings to determine whose cut would be one and like what audience favored. Was it Justin's cut or Blake's cut? And when she was threatening to walk out of her song by Taylor Swift from the trailer, not signing her contract, fighting about, having more time with an editor, they were trying to get more and more control of the film. And on May 17th, the first text message of hers shows, Jen Abel text messages, Justin Belon, and it reads, "He blocked you, is he a 12-year-old girl? Ugh. This kind of thing is ridiculous and part of the whole scam to keep chipping away at you because they know you will catch this kind of thing and then probably acquiesce more to her demands. We can lay the plan out on paper and coordinate with Jaime and Ashmi, so we have all documentation needed of what transpired on set, who saw what, and who would be friendly to go on background if needed to kill her claims, and then a timeline of all Wayfair did to make it a safe set. We will do this together." May 17th, Ryan Reynolds blocked Justin Baldoni. Ryan blocked him, and it was because he was not acquiescing to their demands. And those were threats simmering about what we're going to go tell who the New York Times, and we're going to sue you for what sexual harassment, we're going to tell them what you did on the set. She included that text, and I remember when I saw this earlier, she started publishing all these motions, and I got distracted by all of the filings that are largely irrelevant. I thought that's so weird. Why is Ryan so invested in something that literally has nothing to do with him? right? And Ryan keeps saying in his court filings he wasn't involved, he was just a husband, blah, blah, blah. Why would he have blocked him on May 17th, what was happening on May 17th? Because I don't know that fans picked up on the unfollowing or block until August. And maybe people weren't even really paying attention because I don't know, they just weren't paying attention. Why would he have blocked him? Well, because on May 13th, Sony and Wayfair, they did an official audience test score of his cut. He scored 94% with females under 35, 74% of the people that saw the film would recommend it, 94%. May 16th, they released the trailer to the world. May 18th, Lively hosts a friends and family screening of her cut in New York. She does not share any audience feedback with Bilan or the studios. Ryan blocked him when they were fighting over who was going to get the cut of the film, which has nothing to do with sexual harassment, nothing. They were fighting about Blake getting the cut of this film at that point in time. May 18th, they even have it on the calendar. Friends and family in New York by May 20th. Lively threats to withhold promotion of the film, as well as her barely veiled threat to end Bilani's career with a slew of false accusations. The studio reluctantly agreed to do an official audience test of both versions. The decision was made on the understanding that Lively had agreed with Sony that if his cut tested higher, she would drop the matter and fully cooperate. Test scores come back. She scores 82, he still scores 94, only 59% will recommend her version. Ryan didn't block Justin because he was a sexual predator. No, Blake and Ryan wanted Blake's cut to be the film because Blake wanted to make directorial debut, and when she couldn't get that, then she took over producer, but they also wanted the marketing. They wanted the marketing of the film, and who was going to get paid for that? Ryan. So why would she put out these text messages that show that it was Ryan blocking them in May that got him to realize that they needed to start documenting everything? Because Justin responded and said, I need to hire a person to help me document everything. I can't live in fear, not willing to, but I need you guys very much to have a real plan so I can feel at ease, terrified of what they were going to do to him. Terrified of what they were going to do to him, not him retaliating against her. I also noticed within her CRD complaint, and her amended complaint, and her third complaint, I don't know, she's had a million complaints. She has evidence that is extracted from Cellbrite, which is a forensic tool, and then she also has actual screenshots which would have been taken off the phone suggesting that there were two separate formats used to extract data from that phone, suggesting that she had two separate methods that provided her information. Meaning before it was ever forensically extracted, she was given screenshots. She has a screenshot in there, the exhibits where it's, I don't even know. It doesn't have a date. It's gotta be maybe in August, and it's between Justin and Jen. The photo is a screenshot because it was obviously taken on the phone because it says today at 6:15 a.m., and there's no way that Blake had access to this phone on August 2nd, which is the date that Justin's messages, which are shared in the timeline of relevant events, indicate this was sent. So this was extracted from Jen Abel's iCloud, where her photos were stored as a screenshot, not from the data, as Stephanie Jones would like everyone to believe, and what her art lawyers have falsely argued in court and lied to the judge about. And here's what the text message is about the documents that were sent by Melissa and Nathan to go over their strategy for how to manage the PR and the crisis that was coming their way with the release of the film. And it's just odd, because the 99.9% of these documents and these text messages are in this data form that are extracted from Cellbrite, which is a data extractor forensic tool, because she has one text message where it's like, I'm not in love with the document. They said, I'm not sure that I feel the protection I felt on the call. And then all of the subsequent conversations are apparently Celebrate. That's weird. Did Stephanie just give her this one screenshot to make it look like it was a smear campaign? That's what Justin is saying in his motion to dismiss the response when it comes to Stephanie Jones. It's also what Jen Abel is saying in her motion. Her response to the motion to dismiss is that they had provided text messages to Lively, and they know this to be a fact, and then they needed a cover for why it was legitimate, because had she disclosed those in August, Stephanie would be violating her confidentiality agreement with her and Wayfair, who was her client at the time. And also, the narrative that this smear campaign was happening was fostered by Stephanie. Stephanie is the one that told Blake, it's a smear campaign. Blake already believed it was, but Stephanie was like, yeah, you're right, it's a smear campaign. I noticed this earlier this week, and as I was looking through the documents, and I was like, this is so weird. Why would she include all of these exhibits? And then why would only like 1 or 2 of the screenshots be an actual screenshot from the phone? The rest look like they're extracted from data. But she's got a couple screenshots in here. Okay, I made the decision to review the screenshots of what was taken from Jen's phone. And I wanted to take a look at the validity of these claims. Was Jen Abel's phone being tracked? Was she literally intercepting things in real time? Was she truly just taking information that was data that was stored on the phone? Or was she taking information that was online? So there's a difference of going into a phone forensically and getting the data that is stored on the phone, meaning a copy of the text message that's stored on the phone itself, not on the internet. It's stored in a file. And they have all these different files that they can search, where a copy of your messages, your emails, all get stored onto the phone away from like your inbox. And you don't need to be online in order to get that data because it's actually stored on the phone. But Blake and Stephanie actually screwed up because Wayfair in their timeline of relevant events actually shows the text message screenshot that Blake put in those exhibits, which is the good morning, I'm not feeling that protected. And it's clear that Jen Abel took a screenshot of that and then sent it to Melissa Nathan that same day. And so in order, she sent a screenshot of what Justin told her, and then they have it in their timeline of relevant events, which shows the full context of Jen sending this text to Melissa to show her what Justin is saying. But because they didn't have that string of text messages for whatever reason, and that text wasn't extracted from the phone, they had to get it from the photos. They were able to get pieces of the texts, but they couldn't get screenshots that were shared via text because those were in the iCloud. And so Blake and Stephanie accessed that iCloud to get the screenshots that Jen sent to people. So they are confidently alleging something in this motion to dismiss, and they are not alleging it under information or belief. They are alleging this as a fact. They have evidence to support this. And it says, Jones Works argues that information stored on personal devices, such as Abel's iPhone, does not satisfy the requirements for an SCA violation. However, Abel alleges that Jones Works accessed her communication stored on cloud-based servers owned by Apple and Google. AM counterclaim, 64 courts have consistently held that such cloud-based systems are the types of facilities that the C generally protects. So her allegation is that Jones Works accessed her cloud-based accounts without authorization. That was sufficient at all. Like she didn't have the rights to do this? And she makes clear in her response to the motion to dismiss that Stephanie never had any sort of policy for the phone as far as like personal use versus work use, and absent that policy which an employee can consent to or not consent to. So if they know an employee knows that if they put their cloud on your company phone that you might access it someday, that employee can then opt to maybe get their own phone. But if you don't have a policy, they can't opt in or opt out. So Stephanie needed to have a policy, and she didn't have one. And that's a huge part about invasion of privacy when it comes to employees. And simply owning a phone doesn't mean that an employer has a right to search it, because that data still belongs to the employee. Something I noticed also is they wrote, Abel asserts statutory claims arising from her unauthorized access, copying and dissemination of her private communications and data for Lawlin from her confiscated cell phone. Federal and state law prohibits the unauthorized accessing, copying, and disseminating an individual's private text messages and emails without consent. The fact that Jones Works owned the iPhone did not vest Jones Works with right to extract her personal data from a non-Jones Work cloud account without consent, which Abel never gave. Abel's claims are well supported in facts and law. How do they know for a fact that she was on the cloud? How do they know? I can tell you why. This is how they know. In one of the screenshots that Blake Lively provided in the CRD complaint, that she also provided in her amended complaint, proves that Stephanie Jones was accessing the phone's cloud and data, not the stored information, but the data from the IME messages and the data from her phone, because there's a screenshot included in her complaint in her exhibits. It's from Jen Abel to Justin, and it says, "This is what we would need." And at the top of it, you see it says today at 12:06 p.m. Well, that's weird. Why would she know something that happened today? How did a screenshot happen today? According to Justin's timeline of relevant events, the text message where he sent the Hailey Bieber article that I just showed you was sent on August 5th. How does Blake Lively have a screenshot of a text message that says today on it? How does she have a screenshot that says today on it of August 5th when Jen still had that phone? Jen still had her phone on August 5th. Jen Abel's attorneys through Wayfair have made clear that it wasn't just that Stephanie Jones accessed her phone data, but she accessed her photos which were saved in the iCloud. They screwed up because the screenshot that was shared in Blake's CRD exhibits is likely the A screenshot that was taken by Jen Abel on August 5th and extracted from Jen Abel's photos, her photos in her iCloud over and over and over. Stephanie Jones has lied and said that she didn't access the photos, she didn't access the iCloud, she didn't access X, Y, and Z. How does she have a screenshot then of a photo of a text message sent on August 5th when Jen Abel still had her phone? Stephanie said she didn't monitor the phone before August 5th, so we have to assume that this was a screenshot that Jen took and perhaps sent it to maybe Melissa Nathan to show Melissa like she passed it on, like this is what we need to send. Because Blake Lively's amended complaint doesn't include a Cellbrite extraction of the text message photo that she shared in that exhibit list, her amended complaint doesn't have the forensic extraction of the Hailey Bieber text. It's more than likely that that text message was deleted off of Jen's phone because it's not in the forensic data, but a copy of it existed as a screenshot in her photos, meaning this is why they can confidently say that Jen's iCloud was accessed by Jen by Stephanie Jones. In her motion to dismiss response, they say that Abel asserts statutory claims arising from Jones's unauthorized access, copying and dissemination of Abel's private communications, and data purloining from Abel's confiscated cell phone. Federal and state law prohibits the unauthorized access, copying, and disseminating of an individual's private text messages and emails without consent. The fact that Jones Works owned the iPhone did not vest Jones Works with right to extract Jen's personal data from her non-Jones Works cloud accounts without consent, which Abel never gave. Abel claims are well supported by fact and law and are from more than sufficient to survive dismissal. In the middle of litigation, Jen Abel realized that her iCloud was still connected to the phone that Stephanie Jones owned. How would she know that another device is connected to her iCloud? It's easy on your current iCloud. You can go into the settings on your phone or any device connected to it and see what devices are still connected to your iPhone. If you change the password of the iCloud, any other account that's connected to it automatically gets booted off your iCloud. Okay, so in my house, on my iCloud, I have my account, my husband's account, and my son's iPad, and anytime I change my Apple ID, everyone else gets kicked off the iCloud or I change the pass. Every time I change my password, someone gets kicked off the network, but you can see who's on your network in your settings. So this means that while in the middle of litigation, obviously maybe working with an attorney, they could see that Stephanie was still connected to the iCloud, and they are saying that they know that she was still connected to the iCloud, meaning that her text messages were automatically going to Stephanie the same time they were going to Jen. Like my son's iPad is connected to my phone, so he gets a copy of all of my text messages on his iPad. I know it's weird, right? You can disable that part of it, but two devices can get the same text messages. And so what they're saying is that the amended counterplate counterclaim explicitly states that after Abel left Jones Works, and after Jones Works seized her phone, Jones Work accessed her iCloud account and used it to monitor her text messages in real time and contemporaneously with their transmission, where multiple devices are logged into the same iCloud account. Both receive messages in real time. This is precisely the type of interception FWA prohibits. Simultaneous receipt of emails is interception under the federal wiretap law. So under the law, Stephanie Jones, when she took that phone, should have disconnected it immediately from the iCloud, immediately. But she didn't. It was still connected to the iCloud until January, when she changed out her password. And then Jen could see that nobody else was connected to her phone. Stephanie can lie all day long and say she wasn't accessing the cloud, but she was sending screenshots to Blake from the cloud that were in the photos. Blake messed up because he forwarded these screenshots. Blake doesn't have a copy of the actual text because the text wasn't in the phone, it was in a picture in the cloud, and Stephanie and Blake are so arrogant, they think somehow that these people can't put these dots together, because Jen can apparently go into her photos and see, did I take a screenshot? And if it's as a screenshot in her iCloud, she would know that they pulled this photo from her iCloud. It's not rocket science. So Stephanie and Blake can pound their hands on the table all day long and say nothing illegal happened here. But it did. Blake had no right to have a photo screenshot from somebody else's iCloud in photos. Stephanie Jones had no right to go into a personal iPhone and iCloud because it doesn't belong to Jones Work screenshots, and photos are stored in iCloud if you have your phone set up to photos, which is what Jen says her phone was set up to. She says that her photos were in the cloud, so those photos aren't on the phone. Anytime she went and looked at photos, she was going into Jen's cloud. Anytime she turned that phone on, it was receiving text messages and emails that were already set up on that phone, which she quite obviously did not disconnect from the cloud. Brian Friedman and Mitchell Schuster are not going to make these kinds of accusations if they didn't have proof. And her attorneys, Stephanie's attorneys, trying to act like these are fabricated stories. It's just deflection to try to explain away what they've done. And they'll say, well, they dismissed these other claims. They dismissed the invasion of privacy and the data stuff from the state of California and put them in federal claims, Stephanie, so that you can't fight with them over jurisdiction. And if you put a federal lawsuit in a federal court and you put in federal claims, no one's fighting over if it's New York law or California law. It's all under federal law. And federal law has very specific laws regarding data protection, and employers not being able to look at private and personal accounts even on an employer phone without consent. I think that their motion to dismiss is so well constructed, and I think it's best summed up with this paragraph. Jennifer Abel's altered complaints are the result of her personal data being stolen by her former employer Jones Works and its proprietor Stephanie Jones, following the looting of Abel's personal email and iCloud accounts. Jones Works has initiated a nefarious attempt to demonize and humiliate her and destroy her professional image. Mission accomplished. Abel now lays claims against violations of several data privacy statute, as well as common law claims invasion of privacy, infliction of emotional distress, fraud. It's fake outrage. Despite Jones Works' grounds for termination are weak and complex. They've been yelling and screaming that the only thing Wayfair does is fake outrage. But the thing is, they're the ones faking outrage because they know that they did this. There is no way Blake would have a shot of it from the iPhone without using the cloud, which is a computer that is secured. They're not going to include these accusations there if they can't substantiate it. As set forth, Abel sufficiently satisfies her pleading burden. With regard to her data privacy claims, Jones Works violated Stored Communications Acts by reading Abel's text messages and emails from Apple and Google cloud-based servers without consent. She hijacked her messages in real time through iCloud after Abel's dismissal and seizure of her phone. In accordance with the law, it is illegal for an employer to read any messages after the date of dismissal, that is the day she was dismissed. Stephanie, based on the law, had to take that phone off of the cloud, period. She has no right to excuse that whatsoever. There's no right she has to not take it off the cloud. None. She has no legal right to anything that's on that cloud after the 21st of August. And yet she stayed plugged into the phone, and she forwarded screenshots off the phone to Blake. And then she told Blake wrongfully that it was a smear campaign, knowing very well it wasn't. But the second worst, most egregious mistake that Blake did was that in the screenshots which she displayed in that which are presented to the New York Times and to LA Times, which was never filed with the CRD, and she has supplied any of those screenshots to court. There's really a text from Justin about a story that Ryan planted in the Daily Mail that the script had fallen through. And they're not talking about a smear campaign. They're talking about flipping the story because Ryan really put out a story that he had to fly in and rescue the script because the script was a disaster. Okay. And on the 15th of August, there's a text message that she received in her exhibits that Justin sent to Melissa and Jen, which is, quickly, my partner Steve asked regarding flipping the story from This Leak This AM about Ryan announcing the script was a disaster, and he saved the movie. As for Ryan's declaration, the lady hired was feminist writer, did not know how to deal with a female film using their own words against them. Jen, this went really well, I am going to die, later that same day. So Ryan released a story in the morning of the 15th to the Daily Mail that he had to save the film, and Justin's reaction was, can we get our side out? So the story is not that he wrote in and rescued the script, but that he actually believed that he was smarter than the female writer of the script, who's a feminist. And his own words, the female writer didn't know how to write a script, which is actually the anti-feminist that they've been debating. How does Brie Ryan believe that he's a more skilled storyteller of a woman's story than a woman? Ryan's the one, or Leslie is the one that released that story with the Daily Mail on the 15th. They're reversing the story because Ryan's camp is saying Ryan had to come in and pen the rooftop scene because that script was a disaster, and the film and the book was going to tank, and if he hadn't have done it, it would have been awful. Why wouldn't she place in that, oh, you mean Ryan leaked a letter, leaked something to the Daily Mail, and half of what they were doing was fending off of the smear campaign that Blake and Ryan were making against them. When you start going through these exhibits, you come to realize that it's all defense. All they're doing is trying to bang out and get ahead of all of these leaks that Leslie's doing to the press. Ryan has to save the script. Ryan had to write the scene out. He's going to help Blake. Everything's going to be all right. The first article that was written about this feud wasn't leaked by Mr. Baldoni. It was Blake's team blaming him on the 9th of being chauvinistic and abusive on set. She's the one who made the first jump. She's the one who started the smear campaign, and all they were doing the whole time was covering themselves. And so Blake's exhibits, really that she didn't show to the court, because these would disprove her theory. She released these in December before anyone had a chance to see what Justin had, right? And once she found out what Justin had, all these other text messages just disappear, and now they're not even part of her account. Why won't she own up to the fact that her husband released a story that he had to salvage the script and Justin had to respond to it because it's his film? It was never ever a smear campaign. Just like Stephanie Jones surely utilized the cloud. They are so cocky that this is why no one thinks they're taking this to trial. They completely botched this. And the motion to dismiss reply today made me dig a little deeper to ensure how do they know that the cloud had been accessed. And that's how they know, because Blake has taken pictures of screenshots that were not extracted from the phone data, but were actually downloaded from the cloud. So leave your comments below on what you believe. Make sure you thumb this video up, make sure you subscribe to my channel if you're not a subscriber yet, and click on the bell so you never miss a video. Thanks a lot for watching. Bye guys.